today when we're talking about the trademark, let me understand what is the concern you all will have. The moment we talk about the trademark, what are we looking to understand? The basic understanding of a trademark is when I'm referring to a trademark, I'm looking for a distinguishing feature for my product or my service, right? Because in the market, if I'm planning to sell something, the most important thing is how do I build my brand? So for the brand building, I need to have some distinguishing feature, a name, a resemblance. Most common example of the trademarks which we see around us is all the mobile brands, like talking about the Apple, talking about the Samsung, talking about all these Vivo or Oppo, okay, all these brands. Otherwise, most commonly in the FMCG sector, what we have seen is Cadbury's, Britannia, Parley. These are the most common names which we have seen since generations. These marks, how do I say what is a trademark now? So can I say a trademark is a name that is given to a brand? Primarily, yes. A trademark is basically a representation of particular goods or service, a representation of basically a brand. So it's a logo. Normally, it used to be a logo or any graphical representation of a particular name. But now, since we are evolving with time, what is the evolution that has happened in the trademark industry? Trademarks are no more restricted to my names. Trademark is also about the sound, smell, right? So we are also recognizing the importance of a particular fragrance. So people look to get a particular fragrance protected. Taste makers, the Maggie tastemaker is the best example which we must have, everybody must have experienced, right? So nowadays we are not restricting ourselves in trademark to a particular name. We are also expanding the horizon and we say whenever I'm looking for a particular thing, I want to keep it for myself. So nobody except me should use it. So it's no more a name, maybe it's a sound, a particular taste, particular smell, right? All these are also for my protection. So that gives me a distinguishing feature from the others in the market. So if you have to understand this in a better manner, let me explain you. Let's talk about the noodles. The moment we talk about noodles, how many say noodles? We normally say, I want to eat Maggie. In Maggie, maybe I'm talking about Maggie actually, or I'm talking about noodles, or I'm talking about ramen, right? Because there are so many different brands. Those are serving these noodles to me. But what we say commonly, we replace that with the word we are associated. So we would say, I want to eat Maggie. The moment I go to any store and I want to say, I want a Bisleri, I wouldn't say I want a mineral water because somewhere we start replacing these brand names with the product. Some other examples of this would be some very old example, Xerox. Xerox is basically a brand, right? Photocopy is the process. We get it photocopied, right? Xerox is a brand which started this initiative. So we have replaced that. Now, obviously, the times have changed a lot. But when my daughter was very young, we used to say when it comes to baby care products, we always say Johnson's and Johnson. So it's about a telecom, it's about a soap, it's about a shampoo. We just said I am looking for a Johnson product. I never said I'm looking for baby products. When it comes to creams, in my time, I'm telling you, we used to say Nivea looking for. So these were the brand names. But subconsciously, we replace them with the product, right? So now, what is the problem here in this? When people associate a particular brand name with a particular product or a particular process, what is the challenge? What are the problems? The biggest problem here is it affects the competition a lot in the market. Somewhere it starts creating a monopoly. Because obviously, whenever I'm talking about Bisleri, I only talk about Bisleri. I don't even mention that it's a mineral water. I don't even realize, right? So that is a biggest problem in the market. And obviously, the benefit is given to the person who's captured this. Obviously, the person must have done something great. One, obviously, the first entrant in the market. First entrant will always have the benefit. First entrants get the benefit. Apart from that, the person must have served the quality. So people are happy to associate a brand name with a particular service or a product. So this is an overview. We understand now what is a trademark. Everything we look at, there is a trademark, right? There will be a mark, a presentation that distinguishes one from another. So in nutshell, if you have to understand trademark, what we say, trademark is something that distinguishes one from another. If I'm eating a Parle biscuit, so how would I say I'm eating this Marie or I'm eating some other biscuit from Britannia brand? So I Britannia brand and Parle almost have parallel products, but they have given different names, right? So that's my distinguishing feature. I'm looking to distinguishing my product or service from others available in the market. Now, why only I will get this name as Cadbury or Parle or Britannia? Why nobody else can get? Anybody who wants can use the name Parle. Should that be allowed? I'll give example. Okay. You all must have heard, those who are from Mumbai, you all must have heard newspaper used to have a supplement, Mumbai Mirror. Mumbai Mirror was a supplement paper we used to get with the Times of India. Okay. So obviously few years back in Mumbai only. Mumbai, we say that have two this district. One is a Thane. After Mira Road Bhayandar, we have Thane, and Borivali till Churchgate. Here we call it as a Mumbai. Okay, so one person started this from I think Bhayandar or Virar. Somewhere from there, a person started his own publication, his own paper, a similar supplement, and he named it as a Mira Mirror because this was a Mumbai Mirror. So he said this is a Mira Mirror. Mira is basically station, right? Mira Road station we have, and he was doing this. Obviously, people objected. People said you are infringing my right. What is infringement? You are using something which is exclusively mine, and you are not supposed to use it. So that's infringement of my right. Okay. So people raised no objection. What the other person was defending itself, saying Mira is a generic name, and mirror obviously is again a generic name. So I'm just using two generic names. By no way I'm infringing anybody's protection. Obviously, with some trials, proceedings, it was held that Mira Mirror is actually deceptively similar to Mumbai Mirror. So Mira Mirror had to stop the circulation. Okay, I'll give you one more example. This was a positive example. I'm giving you a negative example. You all remember the gutka brands. We have this one Goa gutka now, right? Normally, those who eat gutka would know it better. We have a Goa gutka brand. Earlier, we had one Manik Chand. They also came up in gutkas. They were also serving gutkas. So what happened? Even if Manik Chand was in the market since start, Goa gutka came later. But Goa gutka got themselves registered beforehand. Okay, then what happens now when Manik Chand is selling a similar gutka? Goa gutka raised an objection because the packaging outlook, everything was very similar, deceptively similar. What is deceptively similar? Something that confuses the minds of the buyers, that which one is true or authenticated. That's deception. Okay. So people raised an objection and it was held. Even if you are there in the market beforehand, you came before the other person, but you did not get the protection under the eyes of law. So the law will not be able to protect you. So this is the importance of registration. The law says people who are seeking the help of the law should come clean hand. That is, you need to be law-abiding citizen to take recourse remedies under the law. Right? So for trademark, this is the most common thing that you need to get your mark registered. Now, registration of a mark, nowadays there are a lot of different categories. We have 2D marks, we have 3D marks, watermarks, right? So many different evolutions are coming. And nowadays, if I'm looking for a trademark registration, I'll quickly brief you about the registration process also. Because of the COVID, almost everything has gone virtual. We realize, we appreciate, we acknowledge the importance of virtual world. Somewhere we will have to adapt to the technology. The technology we just cannot evade, escape. We have to adapt to the technology. Before that, also trademark registry had launched its online services. You could apply for the trademarks online. But obviously, during the lockdown, it has gone much more better. So I can make an online application or an offline application. In fact, to promote the online applications, fees for the online application is 500 rupees less than the offline application. So if I'm applying for a trademark for an individual, the offline fees when I'm going and filling the form is 5,000 rupees and online fees is only 4,500 rupees. So the government is somewhere promoting this usage of online method for everything. Again, I get a form, I need to fill in the form, write down the categories. Now, what are the categories? Those who read the news or see the Bollywood gossips must have heard that Virat Kohli and Anushka Sharma, after the daughter was born, they named her as Vamika and they bought all the rights of that name. So now nobody can get into any business under the name of Vamika because they have already taken the protection. So what does that mean? As I gave you the example of Parle, Britannia, I'll give you one more example. One person is running a software company in the name of Mindcraft, M-I-N-D, Mindcraft. Craft. He's running his business. He's in the software industry. He's also there since quite some time, more than 25, 30 years now. The person is doing very well in his business. Few years back, he got a notice of infringement from another Mindcraft. One more entity registered as Mindcraft, similar name, but they were into handicrafts. This person is into software. They were into handicraft, but the names are same. So now tell me, when I'm going to buy something, is there any conflict when it comes to buying a handicraft or buying a software or a hardware? Am I clashing with anything? Obviously not, because the segments are completely different. So there is absolute no confusion, no deception, nothing which will hamper the interest of the buyer or the seller. So in that case, the objection was not sustained. And both are running their brand names with their respective names in their respective categories. So here the trademark has categories. We have around 1 minute. In trademark, we have different categories, around 50, lesser than 50 categories are there. If I am from legal field, I want to register my name. I am from clothing, education, entertainment. Different categories have their own class, and I need to register myself in that particular class sometime. So talking about the big brands, wouldn't that be tedious for me to apply into all these categories? Talking about Reliance, talking about Tata's, the Adani for that matter. Now they are widening the horizon. They almost venturing into all the fields. So it practically makes it impossible to cumbersome, too tiring, too much duplication of work to go and seek application in the individual categories. So what do? They look for a blanket protection, umbrella protection. So they apply for all the marks across categories. So one single name in all the categories is taken by them. Can we do that? Can any common man, anybody and everybody do that? Normally, yes, these marks are available for anyone and everyone. Anyone and everyone can look for these protections. They can reserve a particular name in all the categories for themselves. For that, you would need a proper justification. Because if this goes so casually, so commonly, everybody will be just blocking the names. And that will demean the purpose of the business. So here, anyone before doing that need to have some, justifying statements, maybe a couple of statements in which they can write down that why they feel all the categories should be reserved for them, right? So this is one. I'm looking for my individual class. I get myself protection in that particular class, or I look for an umbrella protection. So across the class, I have my one name that will be protected. Clear? No confusion so far. What is a trademark? Online format, offline format. Looking for different categories, classes under which we can register ourselves. Okay, then going forward. Now let's understand when I'm talking about a trademark. Trademark is so important. Trademark is the first impression I'm giving to my customers, right? So what all should be protected? So most commonly, I'm talking about one thing. It should have a distinguishing feature. One, two, it should depict some idea about my product or my service. Supposedly, today I'm telling you, I want to start an educational institute and I want to name it as Angry Bird or racing or pick up any name which is highly irrelevant. Okay, I would pick up with any name. So does that name signifies my business? Does that name anyway comprehend, complement my business, my name? Will people have any resemblance with that? Will they be able to connect that? Like normally when it comes to kids kindergarten, people have different names and like Bachpan or Nanny Kali or a tree house or little angels or hungry minds, weavers, different names people have. Somewhere they are trying to give an impression that yes, maybe something to do with toddlers, some activities, some fun, right? So whenever I'm picking up a name, a trademark, I need to ensure that the name suits, justifies, complements the product or service I'm dealing into, right? That is one. And two, I need to have picked up the name originally. It should not be a copy of any other existing brand name because again, that will be demeaning the presence of the other party. So now let me quickly tell you what all names, what all I need to keep in mind while registering for a name. The name should be capable of represented, right? It should be, I should be able to represent it graphically, right? People are putting in the images also. It must be capable of distinguishing. It should have a distinguishing feature from the existing one. How is my name different? It may include a shape of goods, some packaging, some combination of color, some designing. Obviously, normally brand names have that. It must be used or proposed to be used in relation to a particular goods or services. It should be able to justify to that. There must be a purpose for indicating a connection of the trade or business with the name. As I told you, it should be something which is relevant. Okay, so now we have seen what are the basics for a trademark. Tell me when I'm looking for a protection of a trademark, what is the first thing I will be doing? I'll pick up a name. The moment I pick up a name, what I need to ensure that these names are not prohibited by the government of India. There are names and embellishment act. In that, there are guidelines given to me that what names can be picked up, what names cannot be picked up, right? Name something which is as generic as Hindustan, Bharat, India, state, or central, right? These names can never be picked up because somewhere these gives me an idea that there is a government stake which is involved, right? So I should not be picking up those existing ones. I should not be picking up those, right? Something that doesn't suit, that creates a deception in the mind of people about the product or service I'm offering. I should not be picking, right? So we're clear about how do I pick up a name. Now supposedly I've picked up a name. You all must have seen people write TM in a circle or R in a circle, right? People write that. If you all have noticed some material, some marks, some hoardings, websites, somewhere they have TM in a circle, somewhere they have R in a circle. TM in a circle is you have already applied for a trademark, okay? And R in a circle is the mark is registered. Because once I apply for the mark and the mark gets registered, it's a passage of time. Okay. So till my mark is registered, I have to write TM. Once the registration is done, I can use R. That's registered. Yeah. Now I'll quickly explain you the process of registration. As I told you, it is available in the online format or the offline format. Offline format obviously is available since quite some time. There's nothing new. You need to fill in the form, write the customer detail. You have to create your own code on the website, right? So IP India, gov.in, IP India. The office is in Vadala. Those who are from Mumbai, Vadala is in central Mumbai. Vadala, there is an office they have. Online, obviously, you can refer to the website of IP India, intellectual property india.gov.in. IP India is the website. On there, you will find the name of trademark. In that, you go and create your profile first, as an agent or as an attorney, and then you register your client. Fill in the form, upload the documents. What all documents are required? Basically, if you're looking to apply for a mark, first of all, you would need a graphical presentation of that particular mark, right? The logo design. You need to get that image from the client. That image needs to be updated. To update the image, obviously, they have the size specifications mentioned there, right? In what format, in what size you need to have that you need to give. Secondly, whenever you're applying for any mark for any client, you need to get affidavit from the client authorizes you to apply for his mark, right? Third is, if the client has been using this particular mark since quite some time, then what you want a user affidavit. You would say the mark has already been used since maybe 6 months, a year, 2 years, whatever is the timeline you mentioned. That already using the mark obviously creates a better impression. So once you get registered, you can always say that you have been using this mark since quite some time before the registration also. Because not everybody, especially in India, we would say trademark registration has seen some momentum in last 8-10 years. Otherwise, nobody ever was bothered to register their marks. Awareness was very, very low. Now, obviously, people are changing, situations are changing. So almost everybody is looking for a trademark registration. Okay. So here you need to mention the details. So first of all, you mention about the client, his details, the class he is looking to apply for his mark. Suppose sometimes there are different categories. There is an overlap. You would see, then more than one category you can apply for the mark. So what you do? You can ask the client if he's looking for a multi-category protection or only one category. Depending upon the requirement, the fees they are paying, you need to apply for the same. So you pick up a category and you apply for that. Once the form is filled, obviously signatures and all are done by the person who's applying because you have received affidavit from the client. You go to the trademark registry in person, submit the form. There you have to give the DD, demand draft of 4,500 rupees, 4,500 rupees, because you're giving in person. You're going there in person. So you go with the demand draft, the form, affidavit, and submit there. If you're doing online, all these things should be done online. But instead of demand draft, you need to make the payment online. So through a net banking, you can always make the payment. Once the payment is made, the form is submitted, you receive a confirmation because your email, your mobile number is mentioned in that as an attorney. You get a confirmation, the mark is received, information has been submitted. Then the next process is once you submit the application, you need to request them for examination. Because while submitting also, we as lawyers, we as people who are helping people to get the trademark registered, we should do the preliminary search. What is the preliminary search? Suppose if somebody comes to me and says, I want to have my name as Purple, my business name as, Purple Services, Purple Facilities Management, something like they just pick up a name Purple. So what is my responsibility? I go to this IP India website. I check search. There is a trademark search option. So I need to put in that column. I need to search the name. That how many businesses from what all categories are already existing in India with the name of Purple. The moment I get the information, I can direct my client whether you should go ahead with the name Purple or you should change it. Because obviously existing name, I will not get the protection, right? So after the preliminary search, we can guide the client ourselves that the name is viable or not, registrable or not. Because if there is an existing name, then there is no point of having a conflict. Sometimes people have a similar name, but they have different categories. They are not at all connected, and one person's business will never affect the other person. In such a cases, they don't object, and even if the names are same but categories are very different, the registry grants the mark. and people can still go ahead with that. Okay, so once you have submitted a form, the examination is done, everything is fine. What will happen? Then they will advertise this mark. So they will let the world know that this person has applied for this particular mark. So if there is any objection, people should raise the objection, right? If there is an objection, obviously there will be proceedings held. Both the parties needs to submit their proofs, submit their facts and figures, and accordingly the matter will be decided. Supposedly there is no objection, then your mark will be registered. Normally the marks registration process takes around 45 days, but I would say within 3 months it's done, because obviously of corona also the situations have changed a lot. There is so much of workload on the ministries, but within 3 months the mark is normally registered. Okay, so this is the basics about the registration. How do I pick up a name? How do I apply for the application? Now, when I'm talking about a registration, there are two elements. One is I'm looking for a national protection, or I'm looking for an international protection. Everybody must have heard about the treaties and conventions. What are the treaties and conventions? Simple example. If I'm talking about a society, a residential society, there are 50 flats. I tell people that, you are not parking your car. Mostly car parking is the biggest hurdle people have. So I direct people that, everybody has been allotted the parking space. People should adhere to that. So everybody should be parking their car in their respective areas only. How many abide? Normally they don't. So every morning, every night, there is a ruckus created in the society. So what we do finally on one fine Sunday, we call all the members. All the 50 members are required to be present. This is a mandatory meeting of the members. All the members are present. We pass a resolution and we decide the same thing, that parking slots are allotted to the members and everybody should adhere to their particular slot. Everybody has got the idea, but now the difference is we ask all the members to sign the resolution. So all the members have signed the resolutions. After the signature, the members are now bound by the resolution. So it's no more a moral obligation, it is a legal obligation. So anyone who is not complying, I can always fine them, right? It's a valid evidence I have that in a meeting, all were present, a resolution was passed, everybody signed it. Similarly, for these treaties and conventions in the world, how do we regulate? Who will say who's normally countries like US, Russia, these are the countries who are dominating the world. Japan, when it comes to technological advancement, when it comes to their powers, right? They normally dominate. But how much they can regulate other countries? Why would anybody listen to any other country? So for that, we have some of the organizations that are working at a world level. Most common is my International Court of Justice, ICJ, that governs the matters, right? For intellectual properties, we have a body of WIPO, World Intellectual Property Organization. WIPO governs most of the matters of this are IPR related issues. Okay, so now when it comes to WIPO, there also we have different treaties, conventions, people, different countries meet, they come together, discuss a problem, come up with a proposed solution, and everybody signs the resolution. And all those people who are signing the resolution, all the signatory countries have a legal obligation to adhere to the provisions of those treaties or convention. But all the participating countries have only a moral obligation. Okay, so normally we refer to the Rio Declaration, Geneva Treaty. We talk about different treaties or conventions. So I'm looking for a protection under any of those treaties or only in India. If I pick up a particular treaty, so all the countries which are signatory to that particular treaty, I will have protection in all those countries. Since we have evolved with the technology, with a lot of technological advancements, we are trying to remove the barriers of geographical limitations. So practically, we don't look geography as a hurdle nowadays. Everything is so virtual. Here, sitting in India, I can order anything across the world I want. Maybe I'll be paying a little more, but accessibility is not a problem. So if I'm talking about a particular product or a service, I don't want anyone to copy. So I can have a protection in different categories I'm seeking to. Maybe I want to get into a particular segment, I can look for those treaties and conventions. So once I'm registered for a particular treaty or a convention, then all the countries are bound by that database. So in all those countries, anyone doing a business with my name, I can hold them accountable, right? Now, everybody understood about the protection. I pick up a name, I get it registered. Registration is also, my country, different countries in the world. I pick up the treaties and conventions and get myself protected. Now tell me, supposedly I pick up a name and I'm sitting with the name, my business is not doing well and I'm not doing anything. Now should I be sitting with that name? Should I be sitting with that name? Should people let me just sit idly with that name without doing anything? Would that not be wasting the time? A resource is wasted, right? Because people are not able to use that name which they could have used, right? So there is a provision of assignment and transmission. Normally, I'm looking for a trademark. I get the protection. Then I have to keep it renewing. Okay. So every 5 years, 10 years, I have to renew my trademark. Obviously, there is a renewal fees. When I'm applying for a mark, I'm paying a fee. Then for renewal, I have to pay the fees. Sometimes people get the marks registered, but they're not able to use it. They're not able to harness the benefit of the protection. So they can assign the mark to somebody else. They can transmit the mark. Now, what is the difference in assignment and transmission? Both are similar. People use it interchangeably, but there is one little technical difference in these two. What the technicality is all about? Assignment is when I'm giving it willingly to anybody else, just like giving license to use my property. I'm giving a legal license, my rent out my property, so I can let the person use my mark for a particular time for a particular price. Transmission is when it is coming through the law. After my death, it will be given to my legal heir. Right? That's transmission. So assignment and transmission is still allowed because ultimately, if something is protected, it should be used to the maximum benefit. So there is an assignment, there is a transmission. Sometimes people don't renew the marks gets expired. There is a provision for revival also. I can keep adding the classes also to my marks because right now when I'm starting the business, maybe I'm just a small entity. My business is not that big. I'm only in one particular class. Then when I keep expanding myself, I can keep adding the category to my name. Okay, that is also allowed. Then obviously, once when I told you about the registration, when I'm applying, if there is a conflict, any other name, as I said, two names, similar names, but in different classes can still stay together because they are not infringing on each other's right. There is no deception because a person who's buying a handicraft with the name of Mindcraft will not be deceived by a name Mindcraft in software because obviously people would easily know that these two different logos have a different presentation and they cater to different categories. So there is no deception. Deception would be, I'll tell you, when I'm talking about the Cadbury Munch, small Cadbury Munch used to come. When I went to a small town, I just saw Cadbury Crunch. So Krunch. They just changed one word and the name was changed. Packaging, color combination, everything was just the same. This is what is deception. When I talk about the mineral water Bisleri, I saw one person selling Bikleri, Bikleri. This is what is deception. What I'm doing, I'm trying to use the existing brand name which is famous, and I'm trying to deceive the minds of people who are my proposed customers, prospect customers, right? So all those prospective buyers are deceived by me because what I'm selling is not nothing to do with the original. I'm creating a counterfeit, a copy in the name of the original brand. I'm not original. What is the problem? Let people do whatever they want. Why shall we be bothered? Let people sell it Bisleri or Bicleri or Birleri, any name they want to pick up. How does that matter? My brand name gets spoiled because everybody else who's selling in a similar name will not be able to maintain the quality. So all the people who are buying under the pretext of buying a Bisleri will be deceived. And somewhere they will start losing the faith in the original brand. They would say this is a Bisleri which is serving such a substandard thing, right? So because of which we're looking to protect our name. So nobody else misuses that or spoils the name, right? That is the importance. Because if I am selling one product or service with one name, I only should be allowed. If others also start dealing it, then my name will be diluted. It will be difficult for the customers to differentiate between two people, who's original, who's not, right? So this is the importance of the protection for a company, any company, any segment. I think this was the overview I was looking to share with you for the trademark today.
Mike, can you tell a bit about associated marks? And there is a concept called well-known marks.
Well-known trademarks. Perfect.
Yes.
See, what are my associated trademark? Let's take example. As I told you, talking about the big brands like Tata's, Ambani's. So Geo is what? Geo is almost a associate mark now because in the name of Geo, I have mobile. In the name of Geo, I have FMCG. Right? I have Geo Digital, Geo Mart. So many Geo things I have. So this is what I'm associating this with one thing. Is that an infringement? Because this is under one umbrella, one common umbrella. So this is my associate mark. So I'm using it in association with few other things. See, Geo is one group only. Two people come together. Vodafone Idea, right? When I'm talking about Vodafone Idea, so both the names are used by them. Okay, so they are the associate marks. They are complementing each other. They are not infringing. Then if I'm talking about well-known trademark, what are well-known marks? Well-known marks similarly talking about these brands which have established themselves with the passage of time. They have been used since the passage of time. So if newcomer comes in, these are the well-known marks. So they're not infringing, other person is infringing their mark, their customers, deceiving their people, right? So well-known marks are which are already there in the industry with a passage of time. So they have, established themselves. They have got the position. So any new entrant will be deceiving their customers, whereas they are not deceiving anybody. So these are my well-known marks.
Understood. Just an additional question related to it. So, if I
Hmm.
need to, in case of associated trademarks, if I want to assign the main mark, does
Okay.
the associated mark also get necessarily assigned along with it?
No, no. See, assignment are sometimes it's a general assignment. You can assign everything. Sometimes it could be a specific assignment. You decide that what exactly is given. So in association also, you may choose to give only one mark, not the other, because
Okay, got
ultimately
it.
you are
Thank you.
charging a fee for that. No, so the person receiving should also be able to bear the cost of, associate mark, everything together.
Understood. Thank you very much.
Okay, so the first question is who can oppose the trademark registration? Is it only the competitors or even customers or government can oppose?
See, normally the opposition has to come from the person whose mark is registered. Suppose if my mark is registered with a name, let's say I told you, Munch is my registered name, and you also using it. So ideally, it should be done by me. But nowadays, for opposition, even the government, the consumer forums, or anybody on behalf of that whose interest is infringed can also oppose the mark. Because now the consumer bodies they also raise an objection saying that if these two marks are in the market, it is actually hampering their interest. It is deceiving them.
Okay. The next question is how many times one's brand can be opposed by some company or person?
How many times? See, normally it's once only because I'll tell you technically. When I'm applying for a name for a particular, my product or a service, I apply for that, and if I get to opposition, it gets stuck there only. Then I'm not supposed to use it, and
Okay.
still if I'm using it, I'm already infringing somebody's right because the mark is not registered. No, mark will never get registered till the opposition is cleared. Either I prove the opposition is fake, or I prove, if the opposition stands true, I have to withdraw my registration application.
Okay. Okay, so the next question is if an organization's name is similar to that of a brand or a product, does it get the trademark approval?
Yeah. As I said, I'm talking about in trademark, we have different categories, different classes. So if, as I told you the example of Mindcraft, if even if there are two similar names, but they are in far different categories, and there is no future prospect that they would be infringing in the each other's category, then we can go ahead with that name. So even if I have a name which is already there in existence, but my classes are very different, the category I'm applying for, then there is no infringement. I can get the protection. But if other party opposes, saying that in future we might venture into this business, then obviously the opposition stands true.
Okay. And the next question is if a trademark is registered here in India, is it valid for world registration, like international registration?
Yeah. While applying for registration, I have to pick up the category that I'm looking for registration in India or I'm looking for registration in world. Worldwide registration also we have different categories based on the treaties and conventions. So I pick up those countries based on those treaties or conventions. So in those category, I will be registered
Okay.
because normally these gets very costlier. So people are not looking for registration, you know, for the world at large, but they normally look for their clusters wherein they're looking for registration.
Yeah, this is Amit here. One more question I have.
Yes.
Now, there are names that are registered in, for example, the NCA. There are
Okay.
corporate names that are registered. So,
Hmm.
does the trademark infringement law also apply to these registrations? Now, there can be multiple registrations. There can be a partnership firm registration, LLC, or a company, so on and so forth.
Yeah.
So,
See, honestly, talking about the MCA registrations, normally when people are picking up the names for company registration, I'm not looking for a trademark database. Database are separate. MCA has a different database, trademark registry has a different database. So they don't match with each other. But once these companies which have registered themselves under MCA looking for a protection of trademark, then obviously they look for protection, they apply for the application. Normally, practically speaking, in India, the awareness is still very low. People don't want to get into registration. They feel registration is just an expense. Sometimes they know it's more on a face value, personal values, the businesses are running because of the individual. So they don't give importance to the names. But yes, as on date, we have two different databases for MCA and trademark registry. When somebody from company comes for registration, then only the registry checks that what all names are there. And the trademark registry will check the name in its own database, not in the MCA database.
Okay, thank you.
With respect to that statement which you made, that the classes for trademarks can be added later on.
Yes.
So my question was that, say for example, say we have Reliance umbrellas also,
Yes.
and today
Yes.
Reliance is not there in the market of umbrellas, and Reliance
Yeah.
umbrellas has been there for a very long time. But then the
Yes.
company Reliance tomorrow, if it plans to start a unit called Reliance umbrellas, then can they raise an objection for something which has already been there for a while but in another category, and can they say that now we want this class of umbrellas for ourselves, तो आप लोग अपना brand change करो? Can that be possible?
ओके, देखो सबसे पहले आप समझो, जब रिलायंस अम्ब्रेला की हम बात करते हैं ना, तो हर कंपनी कॉर्पोरेट गिफ्टिंग का एक कॉन्सेप्ट होता है, राइट? सो दे रिलायंस अम्ब्रेलास आर नॉट मैन्युफैक्चर्ड बाय रिलायंस, दे आर ओनली गिफ्टेड टू देयर एम्प्लॉइज, चैनल पार्टनर्स और एनीबडी, है ना? तो रिलायंस का अम्ब्रेला में कोई कमर्शियल ट्रांजैक्शन नहीं है. रिलायंस अम्ब्रेलास किसी से ले रहा है, अपना स्टिकर लगा रहा है और लोगों को गिफ्ट दे रहा है. सो दिस इज गिवन आउट ऑफ सम ब्राउनी पॉइंट्स, सम प्रमोशनल एक्टिविटीज, some marketing gimmick. So this is nothing to do with the commercial transactions. You're not adding business by Reliance umbrellas directly. Kal, if they want to manufacture umbrellas, they want to get into the manufacturing business of umbrellas. Again, they will be checking same. Logic is same. The trademark registry will check the names of the umbrella manufacturer in the database. If Reliance is there, then it's a conflict. If it is not there, then they can go ahead.
Okay, ma'am. But they cannot raise an objection way later on, saying that I mean the person who was
Reliance,
there beforehand will be given preference, right? Because that has almost become like a well-known mark.
Exactly. See, if you are asking about the Reliance umbrella, I'm telling you, Reliance umbrella can never be established as a market, right? Because Reliance umbrellas are never there. Reliance umbrellas are given to the people just for the promotion, sales and promotion. Like that, almost every company has their own t-shirts. No, goodies are given by the people. They give their bottles or t-shirts or umbrellas, bags.
Yes,
Does that
yes, ma'am.
mean,
So
does that
I
mean
actually
shoulder
asked
bag?
you that as an example because I didn't think
Yeah.
of any other example, honestly.
No,
What I
absolutely
meant
fine.
to ask is that something which is already a well-known mark in another field, but then
Okay.
another company later on plans to venture into the same field. So maybe, for
Okay.
example, suppose there was something called as Geo umbrellas, and Geo abhi to telecom mein hai, but then later on it plans
Telecom में है.
to expand its classification, is what I'm trying to say. So can they
Okay,
raise an
okay. हाँ, so
objection for something which is
yeah,
already a well-known mark? That was the
no,
Reliance was just a
no.
case in point, actually.
Yes, yes. Yeah, I got your point now. Supposedly you are saying there is already an existing brand of Geo umbrellas by somebody else, not by Ambani's, right? And now
Correct,
in
correct.
future, Ambani's wants to start Geo umbrellas. So can they do that? Ambani's can't do that.
Right.
Because
Yeah. Okay.
the trademark registry rule is very simple. We always give advantage to the first movers. So someone who's already using or someone who got registration. So if Geo
Right.
umbrella is already registered, then Ambani's will have no say. But if they are
And
not registered, then Ambani's might have a chance of winning because the law also says that you need to justify yourself when you say you did not register yourself. Why? So when you are yourself at fault,
okay.
then you might not get the protection.
Okay. So
That's
they
what
cannot.
happened in the case of that Gutka people, right? They were not registered. They were in the market since quite some time, but they were not registered. Other person actively got registration. So they won over the battle.
So the people who registered later on, they won, but it would not come under the law of passing off in this, saying that हम लोग तो बहुत पहले से थे तो भी हमने register नहीं किया. That excuse would not be valid here.
I don't think so. Because
Okay.
obviously, going by the law, it is not allowed. Something which is not allowed is not allowed. Na? You should have registered yourself. If you're not registering, then how can you say it's a passing off? Because law says that those who are coming to law should come with clean hands. So when you yourself are not
Correct.
law abiding, how do you want others to be law abiding? And Geo, in this case, Geo has a strong point saying that Geo has got in almost all the categories. So this one will be adding to the kitty, giving the customers a
Okay.
ease, advantage, access to the market, everything. And those people, if they are not registered, they are actually at a disadvantage because they are fighting against a big brand which is established since quite some time.
Correct. Correct. Okay.
That is the challenge.
Understand.
Because of which we always say look for registration.
Right, ma'am. Right, ma'am. Thank you, ma'am.
How to determine a trademark is a well-known trademark in India and a trademark is a well-known trademark out of India, internationally.
International. See, if you're talking about the database of the trademarks, so databases are available. For India, we have a database on IP India website, right? Our website. And for international, we have a WIPO website. So if you go on IP India also, they will tell you the moment you enter any name, they ask you, you want to search the WIPO database or you want to search the national database. They ask you that.
Okay.
You can search in there.
Okay. And one more question I have. Any
Yeah.
trademark which is means it is well known outside India, but it is not known in India. So,
Okay.
so that trademark can be registered in India or not?
Okay, see, it's a well-known trademark outside India, not in India. So first of all, you need to check the person got the registration in India or not, because the person might not be a well-known here. But as I told you, sometimes people look for signatory countries, right? All those treaties and conventions. So if they are already covered in my country, then it's difficult. I will not get the protection. Otherwise, I can get the protection. People are doing that, right?
Okay, thank you, ma'am.
I can give an example of Princeton. Princeton College, everybody's aware. Princeton University in US, it's such a famous thing. Here in
Yes.
India, in Mumbai, we have a Princeton Academy. So Princeton University is into education of people. Princeton Academy is into corporate trainings. People with the same name, both are functioning
Okay, thank you,
and both
ma'am.
are registered. Yeah.
As you just said, awareness of registering trademark is less. Will you please elaborate on Trade Restrictive Practices Act for those who have not registered their trademark?
Okay. See, I'll tell you, when it comes to, especially India as a country wherein business acumen is very common, almost every fifth house, you would find a businessman here in India. People want to get into their own businesses. So they feel what business they are doing is purely based out of their own face value, their own, personal relations. It's person based. They don't say this is a name based. So they don't give emphasis to the brand name. They're not here to build a brand. They only building their image. In that image building, individual image building, they forget to realize the importance of brand, because these are the perpetual things. If I'm doing a business, people might come to me because of my own personality, right? I have good relations with people. I know people well. But if I'm not there, my business is still continued. That time, the brand name helps me. People can connect with me because of the brand name. And when we are reducing the geographical boundaries, tracking anybody, following anybody based on a brand is important. But people are realizing it gradually. We see a lot of increase in the trademark applications. But the sad part is, initially when they're starting a business, they register the marks and then they abandon the marks. So renewal rates is very low in India, because of which we would say the awareness is very low.
Okay. And the second question is, can a person register their tagline after 1 year or 2 years of registration of their trademark? And how
Yes, that is
often the
possible.
taglines get misused?
Misused. Okay.
Or
See,
yeah.
yeah, okay. See, when you're talking about a tagline, I have got my mark registered. Now I want to add a tagline. Like Nike says, just do it. So first of all, they must have got the tick mark registered. Then they say just do it. They must have got that tagline registered. So if I want to change the line, I want to use the line, add a line, I can obviously do that. There are possibilities there for addition of the marks. That is always there. Again, I need to apply, I need to pay the fees and get this registered. In that also there could be objection, because once I got a mark, it was not infringing. But once I add a tagline, maybe it start infringing somebody else's mark. I'm copying somebody's idea, right? Somebody similar is also in the market, then there will be objection. Misuse, when I'm adding a tagline, if I don't get registered, I get an objection, I'm not registered, somebody else uses that, then obviously it's a misuse, because I don't have protection, so I can't protect myself. And this is also a big problem in India, because when people are applying for the trademark, it is a passage of time. Normally, a mark should be registered between 3 to 6 months. Sometimes it gets delayed. Because of the delay, somebody else, maybe who was already using it, he applied it beforehand, and I was not aware in that particular time. So now what happens? Other person is using it, getting the benefit of the brand, and I have also used it for some time. But now I'm losing on everything because that person got a protection, and I could not get the protection. That is also a problem,
Okay. A
because ultimately,
participant.
who gets the protection gets the benefit.
Yes, ma'am.
Thank you so much.